Welcome to 𝗵𝗁𝗶𝗴. I'm Cristina Caffarra. 𝗵𝗁𝗶𝗴 is a podcast in which I have the privilege of having discussions with people I like and I learn a lot from. And 𝗵𝗁𝗶𝗴 is about really trying to connect dots, starting from antitrust, which is the thing I know most about, but also trying to link up with other areas of policy. There are times, though, when antitrust really becomes much more center stage and raises questions, and this is certainly one of them. I have written about antitrust in the US, in the latest developments, what is known as America First antitrust, perhaps MAGA antitrust, if you like, a couple of times, based on discussion with friends and contacts in the Trump administration, papers, articles, talks they have given. And the consensus has been that the perhaps expansive antitrust push of the Biden administration would be dialed down under the current Trump administration with the new administration, and the scope for intervention would be narrowed, but a strong populist streak would remain, meaning that at the core of enforcement would still remain the notion that we need to pursue the interest of ordinary Americans. Now, reading into what is happening in US antitrust enforcement right now is a bit difficult. Of course, there was an executive order that has revoked the Biden-Harris previous executive order on competition, and that was expected and was saluted both by the Department of Justice and the FTC as a welcome development. But there's also been, for sure, the doubling down on the need to fight concentrated power by digital giants. So we've seen the Google cases, which had been a flagship of the Biden administration, also being continued. We've seen continuation of Apple and Amazon cases, at least till now. At the same time, we've seen a number of merger settlements, which have raised questions and perhaps signal a return to an approach to remedied settlement of deals. And this has really been much less popular under the previous administration. We have seen the rollback of policies like non-competes. Even mention of antitrust is relevant to some sort of ideological battles like freedom of speech, DEI, wokeness, and so on. Then on the positive side, we are seeing focus on algorithmic collusion and pharma, children online exploitation. But really, this is what we'll discuss now, but the conflagration point really for the question of where antitrust is going in the US has been the firing over just a month ago of 𝗵𝗽𝗶𝗴𝗆 and his colleague Bill Reinhart. Roger was Deputy Assistant Attorney General at the DOJ over, as well known, the settling of the 𝗵𝗽𝗽𝗆𝗀𝗎𝗃 case on the eve of the trial starting. Roger actually was always going to come and discuss with me on this podcast the direction of US antitrust, even before these latest developments, of which he has talked about very openly, for example, at the Aspen Forum in mid-August. So I'm very privileged that Roger has agreed to come back and come to the program and discuss what is really going on and give us his views about the question, which is now very salient, of where it might all be going. So welcome, Roger.
Thank you.
Just as a little bit more background before I hand over to you, of course, Roger is absolutely an outstanding American of exceptional integrity. He's professor at Notre Dame. He has deep experience and expertise in antitrust going back decades, and indeed was the head of international at the DOJ already under Trump 1. So again, welcome, Roger. Thank you for being here. And in fact, you and I go back some time because we met first during Trump 1 when you were head of international, and you were traveling to Europe quite a bit, but also what is perhaps not so known is that we've spent quite a lot of time together on the Google cases when the attorneys general in the United States essentially kick-started the entire enforcement effort in the US against Google, which was, of course, also joined by the DOJ. And you were a main advisor to Texas, which was one of the states that led in that effort, particularly on the ad tech side of cases. And I was also working with you as a participant in that effort. So again, you're welcome. Let's start.
Thank you.
And I want to start really from what is America First Antitrust? What does it really mean? I've written about it at the beginning of the administration based on speeches that Gail Slater gave and 𝗪𝗵𝗽𝗶𝗴, but I really would like to set out the vision. You came into the DOJ as essentially second in command to Gail, and she was seen at the time as a champion of progressive antitrust and the so-called realignment.
Right.
So she talked about high-level classic conservative values like moral agency, freedom, individual liberty, but above all, the mission being to protect ordinary Americans on pocketbook issues by promoting housing, healthcare, food, transportation, and so on. Will you give us your version or your vision for what you came into the division to do before things developed the way they did?
Yeah, thank you very much, Christina, for the opportunity to be here. I've had many opportunities and invitations to speak in recent months, and it's just a real pleasure to be here with you to talk about America First Antitrust and some of the recent developments that have happened. So your question was, what exactly is America First Antitrust? I think probably the best signal for what that is would be to read Gail Slater's speech at Notre Dame at the end of April. That was her attempt, I think, to express her vision for where antitrust is supposed to go. You've already written about that. A lot of people have read that and commented on that. My version of America First Antitrust is very, very similar. I gave Senate judiciary testimony in the middle of December prior to my appointment, but after Gail had been announced. And the key idea, I think, with respect to America First Antitrust enforcement is that there is a movement toward a realignment of the Republican Party toward the working class. I mean, if you were to ask yourself what was the key distinction that led Trump to be successful, it was convincing the average working class American that he genuinely cared about their concerns and he wanted to address their issues. And so antitrust is a part of that story, especially the idea of bringing the cost of living down, the prices of goods and services down. And so I think that if I were to say the central message of America First Antitrust is to try to focus on what are the concerns that actually animate the average American about the cost of living, about economics, about jobs and things like that. And so populism in the Republican sense, I think, is focused on trying to realign the Republican Party toward the average working class. And I think that's Gail's central concern. There are other elements to it, but I would say that's the central concern about America First antitrust enforcement.
So that's a nice encapsulation of the principle, and indeed this is the principle on which Gail was very much setting out, and you sort of summarized it, this idea that ordinary pocketbook issues are at the center. Then it comes to enforcement and the practice of it. And when the executive order of President Biden was revoked, as was widely expected, there was, of course, general approval from the DOJ and the FTC that put out statements that praised this move. And you mentioned Gail Slater. She said at the time that what that meant is that instead of an overly prescriptive and burdensome approach, which effectively was how she described the previous administration, the division would promote competition via more tailored action, more tailored executive order, calling, for example, for lowering drug prices and so on. And there's been a description of the approach which has been very much a narrower, more targeted enforcement. The analogy of a scalpel for very targeted intervention, as opposed to what was the more ambitious and expansive notion that one should and could
Right.
use antitrust as a tool for broader, if you like, market engineering.
Right.
Do you want to talk a bit more about what this analogy of the scalpel means and how more targeted, narrowly focused intervention really sort of unfolds in practice?
Sure. So when Gail Slater uses the phrase scalpel, she almost always is using it in contradistinction to regulation, which she calls a sledgehammer. And so when she talks about antitrust as a scalpel, what she really means is we should be really laser focused on specific, discrete problems and trying to address those problems through litigation and enforcement. That doesn't mean you're not aggressive. Obviously, a scalpel is supposed to, do surgical strikes on cancers, but it means that you don't need to take a regulatory approach to antitrust enforcement. And so I think you should think of the antitrust enforcement as complementary to the task force that we initiated, Antitrust Division, and then there was also an executive order on deregulation. The thinking is a lot of regulations are anti-competitive. And so we wanted to try to identify, as part of the executive order and the DOJ task force, regulations that might be viewed as anti-competitive. In a way, you should think of the deregulation executive order as the Trump version of the Biden administration's executive order on competition, but the focus is more on let's eliminate burdensome anti-competitive regulations that often are subject to agency capture, in which corporations are influencing the development of regulations that are anti-competitive. And so litigation and deregulation is sort of intended to be a complement to one another, and that's, I think, the scalpel approach.
So really, this is a very different and not unexpected vision of what is the sort of scope for what intervention should be. Because as we know, in the previous administration, there was a vision that intervention through rulemaking, through other measures, could be quite expansive and change the way in which markets ultimately sort of function or behave in ways that were intended to improve outcomes, of course. And what you're setting out is a very different perception of that kind of action, rulemaking or regulation, as being often intrusive, often ultimately working against the general interest, and preferring a much more narrow approach.
Yeah, it doesn't mean that all regulations are anti-competitive. It meant that the agencies are tasked with the objective of identifying those regulations that are anti-competitive and then propose which ones should be eliminated. It doesn't mean that we're anti-regulation in all respects. There are obviously many regulations that either are pro-competitive or that serve other legitimate government objectives, right? And so it doesn't mean that it's across the board. But yeah, that's right. And the idea would be that we should be more focused on litigation. I would say the other thing that's important to note is that we're still in really early days within the Trump administration. And a lot of the work that has been done thus far is, I guess you could call it legacy cases, legacy mergers. And so at the same time that we're trying to address and resolve those cases, we're trying to launch new initiatives. The DOJ is trying to launch new initiatives, especially with respect to key industries, healthcare, housing, agriculture. Gail Slater just had a big meeting with farmers in the Great Hall at the DOJ yesterday with farmers. So there's a strong interest in trying to identify key priorities that are responsive to the America First initiative, at the same time that we're trying to deal with the legacy cases. Very often, the legacy cases are very consistent with America First, right? The pocketbook issues were a key part of some of those cases, right? The 𝗿𝗵𝗽𝗍 case on housing, healthcare issues, and the investigations in the healthcare industry. You can certainly imagine a whole variety of different issues. The case against Visa and Apple and all those cases had various aspects. Certainly, AgriStats was an example of a pocketbook issue for the average American. So it's not like we were like denigrating the holdover cases, but it's still in the early months where Gail's not able to really fully embrace her agenda, and she's trying to deal with some of these older cases as well. And that's especially true in the merger context, I think, some of the merger cases that have been holdover cases.
And indeed, I was going to move on to specific areas of enforcement like mergers. And of course, given the developments in the last few weeks, this is very much at the core of what really led to your leaving the DOJ. And we don't intend to talk specifically about a case, but about the general approach. You talked about the case in any event, and certainly you have no hesitation to talk about it. But the difference, which is very apparent to observer, is that during the Biden administration, you had a pretty aggressive approach to merger enforcement, with a lot of deals being challenged in court, some successfully, many successfully, in fact. What we have seen, I think, is not controversial, is the idea that what we can expect are many more settlements. So instead of challenging deals, trying to find some sort of solution and settling them in ways that had, I have to say, gone quite out of fashion in the previous administration. The perception was settlements don't work. You don't restore competition effectively with a settlement. You don't really get to undo the bad effects of a merger. So instead of doing a fudge, it's better to stop the deal altogether, because markets are more concentrated, are too concentrated anyway. So what we've seen is certainly a greater inclination to settle cases. And some of them, and I just rattle through some, based on, indeed, some form of agreement or concessions or remedies. So there was, of course, the Paramount Global Skydance Media. There was the American Express global case with CWT, T-Mobile US Cellular, United Health Amidis, which again was recently settled, I think only days ago, finally, with a number of divestments. And indeed, the HP-Juniper case, which was at the heart of your disagreement with ultimately, I guess, the hierarchy, and led to you leaving. So what is your view, aside from the individual case, about the approach? So was the previous administration clearly overdoing it? Are we going into a world in which settlements actually are not to be overlooked as a possible solution to a deal? Are they preferable to challenging deals? What is the general approach here? We are turning back to a world in which many more deals will happen and are welcome. What's the vision?
Yeah, so it's a very important question. It's one of the most important issues that we've been dealing with lately. And I want to just preface my comments about the Biden administration by emphasizing that in the first Trump administration, there was a high degree of willingness to challenge mergers that were viewed as anti-competitive, even though doing so might be controversial. And the most famous example, of course, is the vertical merger in AT&T Time Warner. There had not been a vertical merger challenge in decades, and the fact that that was the first major challenge out of the gate in the first Trump administration, I think, is very notable. There's other examples of significant merger challenges. For example, 𝗵𝗽𝗏 was a sort of a nascent competition merger challenge that was, I think, very significant. So there was a willingness in the first administration to be aggressive on antitrust merger enforcement compared to the Bush administration or the Reagan administration. But I do agree that the Biden administration was more aggressive in merger enforcement than in the first Trump administration or in the second Trump administration. And I think that was most notable in 2 or 3 different ways. One, early terminations were not practiced for almost the entirety of the Biden administration. And obviously, early terminations simply say that if it's not a competitive issue, then we should try to get out of the way and let the parties close as soon as possible. We shouldn't force them to wait 60 days if we can assess the situation in 30 days and let it move forward. That is a big difference for the parties with respect to pro-competitive mergers. And then the other major difference is the Biden administration rarely would do settlements in mergers that were subject to consent decrees and Tunney Act review, they would pretty much say to the parties, bring us a clean deal, and if it's a clean deal, then we'll let it go through, but if it's not a clean deal, then we're going to challenge it. And so the idea of this sort of middle path of a negotiation to try to fix the problems, because obviously the merging parties and the DOJ or FTC might not agree about what exactly is a clean deal or is not a clean deal. And so the concern, I think, for Gail Slater and for the Antitrust Division in the second Trump administration is we need to be able to approach some of these deals as potentially available for settlement if we can make the right corrections. And there have been good settlements, I think, in recent months. But as you know from my speech in Aspen, there's also been bad settlements. Gail Slater, in her Senate testimony, said we don't want any bullshit consent decrees. That's not what we're about. And then all of a sudden you have _Juniper merger, which was opposed by the Antitrust Division top to bottom. And so that was why it was just such a shocking turn of events that I spoke about at the Aspen Institute. So I think those are the two major differences between the two administrations. We are still waiting for enough of the sort of mergers to go through the pipeline that we can do the enforcements of Gail's agenda. That's the other thing, is they take so much time, so much effort, and it sort of takes time away from the work that you want to do on conduct enforcement cases.
And we'll get back to this at the end, but I want to go back also to what you just said around really a judgment that you made, that there are some settlements that are acceptable and perhaps more acceptable to you than in a vision that was very much against market concentration, typical of the previous administration. And there are settlements that are simply not facially acceptable, but more problematic.
Right.
The signal that sends to the world, as you know, and you spoke about it in Aspen, is a difficult one, and a difficult one for the division and for Gail. Because what the world takes away from it is almost a license to go forward in a particular way. And Gail has spoken about it in her Ohio State speech, which we'll go back to. This is, I think, a pretty existential question for an enforcer. Are you in a position, you are out now, but of course you've expressed strong views. And, you know, of course you want to support Gail's agenda, but it is something that everyone is at the moment kind of struggling with. Are we going to see merger enforcement kind of go back to a reasonably even keel, or is there going to be a prevalence of lobbying and influence?
I think the jury is still out on that, to be honest, Christina. There are examples that are highly problematic in which the rule of law was not respected with respect to some settlements. And I spoke about that very explicitly in the Aspen Institute. And there are also examples where there's an effort to settle on the cheap, in which the Antitrust Division, including Gail Slater, are resisting. And so part of the reason that I gave my speech was to try to highlight the fact that this is happening, and it's happening in a whole variety of different cases. And there needs to be greater scrutiny of the fact that these law firms and the clients of these law firms are accepting this as a possibility to basically resolve things based on political connections rather than on the legal merits, which is highly problematic and highly unethical. And so I would say that the jury is still out. There are certainly examples of good settlements. And I think a really good signal of a good settlement is the fact that you had cases like Greystar in the RealPage case, the largest landlord in the United States, or cases like Amedisys and United Health, where state AGs across the political spectrum that are joined in the case have agreed with the settlement. And so I think the fact that there was not expressions of concern by the Democratic state AGs that had joined those cases is an example of, I think, that we worked through very difficult issues and reached a good result in those cases. So I think there are certainly examples of good settlements, but unfortunately there are examples of bad settlements, and that's where we are right now, and we're trying to correct that, and hopefully that will be corrected with the kind of ideas that I proposed in the Aspen speech.
Indeed, you mentioned the role of the state AGs going forward as being an important corrector or certainly guardrails to what is being done, to the extent that indeed there is a sense that if states are moving with, and particularly blue states as well as red states, moving ahead with a settlement, then that is a signal that something is supported. But yeah, indeed, it's difficult to move on from this subject because it is so salient what happened in your case. More broadly, I see that the head of Goldman Sachs says we are opening the door to a merger wave right now, because the perception is that this is much easier to be done than in the past, and indeed that is something that needs correction. So Roger, moving to another area of enforcement beyond mergers, of course, there's conduct. So there are all of these cases that were started, in fact, in some cases under the Trump 1 administration, and then they were pursued, particularly the case against digital companies. We'll get to Google in a moment, but they seem to certainly be continuing under this, under the current administration. There is also a sense, though, and there is a report, for example, from a consumer advocacy group that also says a number of enforcement actions have been ultimately dropped. But also, looking at the general landscape, and that's beyond the DOJ, there is a sense, again, looking at it from outside, that enforcement and antitrust enforcement is being used to pursue agendas that are unusual for antitrust enforcement. Things like freedom of speech, a view against DEI and wokeness, and so on. This is particularly true, of course, of the FTC, which has puzzled a number of us looking at it from the outside. Can you comment on that?
Yes, absolutely. I do think that you're right that there are elements of America First antitrust that are not purely focused on pocketbook issues. They're also focused on, I guess you could say, cultural elites and the concerns about cultural elites. And that has manifested itself most notably, I think, in some of the decisions that have been taken by the FCC and the FTC, with respect to DEI or with respect to conservative bias concerns or things like that. Andrew Ferguson gave a very, I think, sharp speech that you and I attended in Chicago about that, his concerns about antitrust and conservative bias. I think what is notable is that to the extent they are making those arguments, the FTC and the DOJ are strongly committed to remaining within the camp of consumer welfare standards. So if you're going to try to make those arguments, you have to be able to cabin them within the context of consumer welfare. And so if you look at the BlackRock amicus brief that was filed by both the FTC and the DOJ with respect to ESG, that was really about output restrictions between common shareholders. And it was very much written as, to the extent the facts are as alleged, in which there is potential collusion between shareholders to reduce output, then that could be an antitrust concern. And actually the court in Texas agreed with that. So it was an ESG issue, but it was about a central antitrust concern. And then the recent amicus brief that the DOJ filed, different than the FTC case, with respect to conservative bias in media, was if there was collusion between legacy media with respect to the information or the kind of stories that they would publish with respect to COVID, then that had the potential to be an antitrust violation, because obviously in the media space, the kind of information that you're providing and you're colluding about what is reportable or what is not, that has a potential to be an antitrust concern. But I agree with you that there is a legitimate concern that the antitrust enforcers at the FTC and the FCC, I think, are embracing the culture wars with gusto rather than focusing on the sort of core concerns of the American worker, which are, I think, more pocketbook issues. And so, we want to, as Gail would always say, we want to keep the main thing the main thing. And so, that means making sure that you really keep your eye on the things that matter to the average consumer, to the farmers, to the renters, to the blue collar workers that are just trying to make ends meet and things like that. And so I think that's I think where we should really be focused on.
But indeed, picking this up, one popular rulemaking of the previous administration, as you know very well, was around non-competes. And this has been effectively killed with great gusto from the FTC, notwithstanding Rebecca Slaughter's brief reinstatement and effort to keep it alive, on grounds that it is effectively something that was, as I understand it, not really within the mandate of the Commission to be effectively ruling on. But it was a hugely popular policy that thousands of Americans welcomed.
Right.
And the position that something like that, which has the potential to be very beneficial to ordinary Americans in their search for a job, is pulled back on grounds that somehow the law doesn't permit us to go that far, seems, again, very indicative of an agenda that is difficult to reconcile with, favoring ordinary Americans, while instead focusing on elite issues, as you say, like freedom of speech, that don't really touch on ordinary Joe in the same way.
Right. Yes, I do agree that non-compete agreements are the corollary to the concern about no-poach agreements, right? And there have been strong Republican support for enforcement of antitrust laws with respect to competitors colluding with one another to not hire each other's workers. And so with respect to no-poach agreements, there's strong Republican support. I think Republicans are divided about non-compete agreements. And the question is whether or not that should be done through a regulatory approach or whether it should be done through a more litigation-oriented approach. The FTC in the Biden administration focused on it through a regulatory approach. And I think at least some of the Republican voices were concerned that that was an overreach, right? And I think if you read the different statements, in a earlier period of my life as a professor, I would teach non-competes in contract law. And usually in contract law, they're viewed as like, well, how long is the non-compete and how geographically broad is the non-compete and how broad is the scope of the non-compete? And at least in contract law, non-competes were always viewed as like, well, it sort of depends on the language of each individual agreement. So I would agree with you that that is an example where it was a very popular measure, but the FTC decided to vacate it. And I think probably the best way to look at it was to try to read Mark Meader's statement, to sort of express, he's very interested in aggressive enforcement, but he sort of expressed, this is my reason why I was willing to pull back on it.
So now you and I cannot have a conversation without talking about the Google cases. I think it is the time when we are moving into that. And again, as I hinted at the beginning of this, we stood 6 years ago, almost to the day. In fact, it was to the day there is a picture of me and you standing next to one another with 52 state AGs on the steps of the Supreme Court, as a number of state AGs led by Ken Paxton and many others were essentially stating their reasons for moving against Google. That was the beginning of the reawakening or the awakening against effectively digital monopolies or digital platforms in the US. In Europe, there is a different history. We've been there for some time, but really 2019 was when the states moved, and then the DOJ and the federal agencies came along. So having lived all of that, because you were absolutely central to the initial sort of multi-state coalition, which then sort of somewhat split as between search and ad tech, being central to the ad tech case for all those years, but also involved in search. Here we are at this point in a situation in which we had two pretty good liability decisions on the part of judges, both on ad tech and on search. But then we just received quite a blow with a search remedy decision, which is being widely described as a huge disappointment, in which Judge Mehta, in other ways, of course, a man of a decent man of great integrity, does not follow on his own findings with a set of remedies that makes anyone think it's going to do something. And I'm not even talking about Europe. We just issued a very weak decision on ad tech, almost a nothing burger. So do you want to comment on how you feel about that? And more generally, and where are we in this platform antitrust enforcement effort, which is being global? Everyone has been looking at the US and, well, you know, we are not doing very well in the rest of the world, but wait until the US comes in. They have the ability to do things. They have the ability to break up platforms that we in the rest of the world don't have. We ended up in a place where, you know, generally the US doesn't seem to be particularly mandated to do very much. Of course, we still wait on the ad tech decision, and Texas is doing its things. Give us a sense for where you think things are.
Yeah. So I would say in the first Trump administration, there was a strong interest in addressing big tech antitrust violations. It took literally months to decide which agency will deal with which big tech company. And then finally in about 2017, the DOJ, you know, basically had the Google case and had the Apple case, and the other two, Amazon and Facebook, went to the FTC. And so in 2017, we really began to develop momentum at the federal and at the state AG level, and as well as private litigation against big tech from the Republican side, not just from the Democratic side. And as you said, September 9th, 2017, we were on the steps of the US Supreme Court, in which at least a dozen, maybe more than a dozen state AGs, both Republican and Democrat, were there saying that we're going to launch an investigation, and the CIDs were issued that day. And at the same time, the federal DOJ, FTC, they were really like ramping up their investigation. And so the DOJ filed its search case in October of 2020 against Google. And then the state AGs, bipartisan state AG actions, were filed in December of 2020, both with respect to ad tech and with respect to search, especially the vertical search with Colorado and Nebraska, Doug Peterson and Phil Weiser. And so this has been a long-standing initiative by Republicans, both at the federal and at the state level, to go after the big tech companies. And there have been very successful wins. The finding that Google is a serial monopolist is very significant, and we should celebrate that. The finding that there have been success, the Epic Games litigation, is, I think, incredibly important as well. And the jury's still out about what Judge Brinkema is going to do in the ad tech case in mid-September. So I would say this about Judge Mehta versus Judge Brinkema. The personalities of those two judges are very, very different. And so I think you have to manage your expectations about the ceiling of what was possible with Judge Mehta compared to the ceiling of what is possible with Judge Brinkema. And Judge Mehta was always strongly committed to trying to follow the DC Circuit precedent in Microsoft and trying to anticipate the possibility of being overturned on appeal. And so if you read his decision, you can see very, very consistent statements about being cautious, about being humble, about I'm not an expert in this area. I don't know the area like someone in the industry knows the area. So there was a real cautiousness about Judge Mehta, and therefore I think the upside was probably less than what might be the upside with Judge 𝗵𝗽𝗻𝗁, who's a rocket docket judge, who's very firm, very committed, very confident in her positions. And so I think the jury we'll see where we go with the ad tech case. And so, you know, Jonathan Cantor in the New York Times said that Judge Mehta basically missed the goal. The hockey puck, the hockey puck went outside the goal. I think the better analogy is not hockey, but baseball. And so I think that I would say that Judge Mehta did not score a home run or a triple, but we have a double or maybe a single. There were 4 or 5 major overlapping, interlocking remedies that were being proposed in the search case. And, revenue share agreements, limitations on that, syndication, data sharing, and then, the breakup of Chrome. And some of those were wins. I mean, to be honest, the data sharing was a pretty big win in the sense that legally it was uncertain whether or not Trinco applied not only to liability, but also to remedies. Google argued very strongly that it should apply to both liability and to remedies. The judge said, no, data sharing is okay as a liability remedy, as a remedy for trying to basically unlock the potential of the other competitors. I also do think that the judge was incredibly conservative about error cost analysis, and he was viewing Google as fragile and as potentially the kind of thing that could be overtaken by events. The AI paragraphs in the opinion are quite notable, that he really sincerely believes that AI is going to be a competitive threat in the near term. And that, I think, is one of the reasons why he was cautious. He notably included AI in the qualified competitor definition. So that means data sharing and syndication should be available to AI competitors. That's a departure, I think, from where we were in the liability case, where he embraced the idea of these Gen AI entities being potential competitors that could then benefit from some of the remedies. But I agree with you that the judge did not, take a full swing and really address all of the concerns that he could have. And I think it just reflected sort of a very cautious Chicago school approach. The fact that 𝗵𝗽𝗶𝗴𝗆 and that the treatise was cited 30 times, he almost treated that as if it was literally black letter law. Anything that came out of that volume of treatises is black letter law, and I thought that was quite interesting. And so I think we'll see. Let's see where we are in 6 months with the ad tech case, and then reassess. I mean, so those are my initial thoughts.
But Roger, okay, a number of reactions, because of course I have a big investment in this case on a personal level, much as you do. But so we're here discussing the personalities of the judge, and of course this is the system. Ultimately, the judge makes a decision, and you're saying the judge was more cautious. He had a Chicago inclination. He quoted 𝗵𝗽𝗶𝗴𝗆 30 times. And it is, I think, certainly not reassuring that in a case of this kind of significance, with such enormous effort expended into it for years, we end up ultimately talking about the personal vibes and inclinations of an individual. And we're here hoping that 𝗵𝗽𝗻𝗁 will be somewhat more courageous. This somehow feels all extremely unsatisfactory. I realize it's the system, but it is not where you'd like to be. And, I also realize that you are, of course, pulling out some aspects of the judgment that appear, or the remedy judgment that appear to be not entirely a loss for the DOJ. But taking a step back, there isn't another bite of the cherry in the search case. We are kind of done, because the DOJ may well appeal, but it is difficult to think that this kind of position would be overturned. And so you quoted Jonathan Kanter in the Wall Street Journal or the New York Times. Mark Lemley published a piece yesterday or day before in the Financial Times in which he said, basically, we cannot use antitrust to regulate the concentrated power of platforms. And it is difficult to escape that kind of conclusion, also coming from Europe. Look where we are. We've been at it for 15 years. And clearly, we're never going to do anything terribly radical. The geopolitical environment now is such that we don't want to create any more irritation across in Washington. But it does raise the question of what can anyone do to somehow control that power? And is it controllable? Is there a prospect that any of this could be controllable by anyone? Yes, we're still hoping for 𝗵𝗽𝗀𝗻 somehow doing something on ad tech. But the bigger question, I think, for antitrust at this point, which is one I think about a lot, is what are we doing? Should we be less ambitious then, because we don't seem to be able to actually affect that power in a meaningful way? Look at what we've done. Look where we are. We are nowhere better than we were 6 years ago, 7 years ago, 10 years ago. In fact, worse. So there is that question, which really I think is very salient and makes me question, what are we doing in antitrust in this space?
I agree with you that it is discouraging, and you know, it's uncertain whether or not these remedies will be sufficient. And it's disappointing when a failure in Europe, like choice screens, led to the judge in this case saying, well, I'm not going to even propose that remedy because it didn't work in Europe. And you and I have talked at length about why the choice screens didn't work in Europe and how they could have been structured differently. It's disappointing that the judge in Judge Mehta didn't recognize that things like product design could be part of a remedy when it clearly was viewed as a legitimate remedy in the Epic Games case. You know, so there's examples of things where it's just clearly disappointing that the judge. I think the biggest point would be that these cases are way too expensive and take way too long, and Google literally just benefited from its delay tactics. The emergence of AI was a significant, the judge was very clear that the emergence of AI was a very significant part of that. And I think that the government enforcers should be thinking about more rocket dockets, right? And not bringing cases that are going to take 5 years, because people speculate that if we had done the Google case in a rocket docket, then we might have been successful. Texas tried to do that in northern Texas, and then Google played the delay game and got it to an MDL in New York, and then we literally had to have a statute passed to get it back to the rocket docket. But in the meantime, you know, we're still in delay tactics. So I agree with you that these cases take too long, they're way too expensive, and it is discouraging if at the end of the day this is where we are. And we'll just have to see. Maybe I do think the potential for structural remedies is greater with 𝗵𝗽𝗀𝗻𝗿 because of the nature of the judge, but also the nature of the market, where there was an acquisition, and the vestiture of an acquisition, even Judge Mehta said, is more legitimate. So we'll just have to wait and see where we are with some of these other cases as well. I think it's understandable to be discouraged, but it's also, we shouldn't say that we just completely struck out, right? I think it was a single or a double rather than a triple or home run. So.
Oh, I think, as I've said repeatedly, I think in antitrust terms, only Google disagrees. The rest of the world agrees that these are egregious cases. There isn't even a question that they are effectively very solid cases, both search and ad tech. The question, though, I think remains, and you agree with me, whether for a variety of reasons, the time it takes and the lateness we are and the position we are in the cycle, where anyone can do anything about it. And it isn't about being discouraged. I personally never thought possibly, or recent times didn't think that these judgments were going to turn history back in any way. The question, though, is ultimately, can we conclude that antitrust can be used to disperse gigantic market power? Or is it going to be actually something where we should be more modest in our ambition, deal with cartels, deal with egregious behavior in more traditional industry, because we don't seem to be able to actually make a big difference? And I'm repeating myself, and I don't want to return to this, but I am at a point where I think there is a big question that people need to consider going forward in terms of what we want antitrust enforcement to do. So this, I'm coming to an end, and of course this has been a wide-ranging conversation on different aspects of antitrust. I want to just wrap up on with your thoughts on where it is all going in some sense. We have heard you express general support for the agenda that Gail is trying to pursue. You certainly have shared with her that vision, the concern about a more transactional approach that has crept in. And indeed, Gail expressed this strongly in her Ohio State speech just a couple of weeks back, in which she was very concerned about what she calls the tragedy of the commons in some sense.
Right.
If the rule of law is not really supported as a general good, who is going to actually put themselves out there and work in the public interest? So this is very much where we are. I think we are at a time in which it's not clear where things are going. Things need a correction in some sense, and I hope it will be implemented. There have been positive things, but do you want to leave with some final thoughts on where you think things will be and how you think things will evolve?
Sure, yeah. I think her speech at Ohio State, which was, been in the works for months, we've been talking about it for months, is really an important speech. Because what it really is trying to say is that we're in a crisis with respect to ethics right now in the antitrust bar. And it is crystal clear that the law firms are not rising to the occasion. They're not being good stewards of the rule of law with respect to antitrust enforcement. She gave examples of denial, literally refusals to comply with judicial decisions, with destruction of documents, with privilege abuses, the delay tactics. She gave lots of examples in that. And then, of course, in my speech, I gave the example of clients and law firms openly willing to use political influence and lobbyists that don't know anything about antitrust to try to resolve cases rather than resolving cases on the merits. And I think we should recognize that we are in a crisis of ethics with respect to antitrust, and it's critical that that we address the concern. And I know that Gail State is trying to address the concern. There's also obviously a crisis of ethics with lobbyists. The GCR had a recent article that said that even traditional K Street lobbyists are embracing this new approach with Ballard and Miller strategies and things like that, that they're having 2x, 3x amount of lobbying on antitrust that they've had in previous years. It's not just the MAGA lobbyists, it's also the traditional lobbyists willing to embrace this ethical compromise, bringing in political influences rather than resolving cases on the legal merits. And so I think that's something that has to be addressed. The ABA antitrust section should take up this cause. There are lines that should not be crossed. And right now there's a whole variety of different lawyers in prominent law firms that are willing to cross these ethical boundaries that I think is clearly problematic.
But in a sense, I mean, Jonathan Kanter was complaining about issues of ethics during his tenure. He was denouncing, for example, quite vocally the fact that conflicts were not declared by experts the whole time. So this is what appears to be an evolution of something we all know very well, happens in practice, and ultimately boils down to lawyers will do what's in the interest of their client. The question is whether it works or whether they're being told to knock it off. And
Right.
the question is also how and who is going to tell them to knock it off. The DOJ has launched an initiative, but it is hard to see that something that delivers result will be necessarily abandoned. So it is a difficult spot, and one which I think is going to persist as a question, notwithstanding, of course, the good intentions of the people inside. But it is something that preoccupies everyone. So, Roger, thank you so much for being so candid and so generous with your time and your views. I am, as always, privileged to be a friend of yours, and I'm very grateful that you had the grace to be here today, and I'm sure people will learn a lot from this discussion. Thank you again.
Thank you very much, Christina. It's been wonderful.